Hi everybody, welcome back to WDMD 100. This is lesson 8 and this week we are going to be talking about copyright. So let's jump into the slides. Okay. My computer is trying to make me change some settings here. Just a second. Okay. Hopefully that works. All right, so copyright this week. What is copyright? Well, first let's go through some popular myths about copyright. For example, if an image is on the internet or Google, it is in the public domain. What that means is, if the image is found on the internet or in Google Images or Google Search, you can use it in your schoolwork, projects, work, whatever. Not true. Everything that is created by an artist or created by anyone really belongs to them and is copyrighted by them immediately as soon as they create it. So just because it's on the internet doesn't mean that it's free to use unless it actually notes that it's free for you to use. So another popular myth, if there's no copyright notice on the image, I don't need permission. Not true. No matter where you find an image, whether it's online or not online, if there's no copyright notice on it, you should still assume that it's copyrighted. And if I don't profit from the use, I don't need permission. That's also not true. Well, there are some ways where you can get around this using, education and research and reporting. For the most part, if you don't profit from use, it doesn't matter. If it's harming the artist or creator in any way, you could still be liable for copyright infringement, and you could still get sued or possibly have to pay damages for it. More myths, if I remove the image after notice, like after somebody complains that you've used a copyrighted image, I don't owe any money to copyright. This is false as well. If I alter the image a certain percentage, I don't need permission. Also false. No matter how much you alter it, you may still need permission to use it at all. Or if I only use part of the image, I don't need permission to use it. This is also false for the most part. We're going to look at some appropriation artists who kind of get away with this sort of thing. So really, there is no clear line between right and wrong in copyright. However, there are definite cases or court cases that we'll look at that determine or that show sort of what goes into thinking whether or not something is copyright infringement or not. It gets kind of interesting. So copyright. The U.S. Constitution gives Congress the power to enact laws to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. That's copyright. So what are some things that are copyrightable? Things that are protected are, particular expression, a total look and feel, so like songs, writings, images, video. Things that are not protected are ideas. So if I have an idea, like say I came up with the idea of the zombie run where we're gonna run a 5K and zombies are gonna chase me, that idea is not copyrightable. It's just an idea, it's not tangible, you can't hold it. Or an expression merged with an idea. That is also not protected. Commonplace subjects and compositions are also not protected. So say, let's say that I was going to paint a painting or take a picture. Let's say I'm going to take a picture, and I'm going to take a picture of an apple sitting on a table. Well, that picture is so commonplace because just about anyone could come up with that idea to take a picture of an apple sitting on a table. You could come up with that idea yourself and do it. It's so commonplace that it wouldn't be copyrightable. The US government would probably deny it for copyright if you submitted it to them. So copyright protects original works of authorship that are fixed in a tangible form of expression. That means it's something that you can see and hold or, recreate, look at. Things that are not tangible, of course, are like ideas. Anyone could say, put down an idea on paper and then somebody else could say, well, I had that idea already and I copyrighted it. No, that's not going to happen. So copyright protects anything that is tangible, something you could see, feel, touch, read. Yeah. Rights actually begin at the moment of fixation. So right when you start creating, when you create this tangible object, whether it's a song or a dance or a writing or an image, that's when your rights begin. However, we will go over later how to actually copyright protect something and actually register it, copyright with the US government, because if you ever are infringed upon and somebody steals your photo or steals your dance or song, you need to have it registered in order for you to really claim any damages or get any compensation for the infringement, even though technically the copyright is yours when you create it. So what is protected? Literary works, all text including computer software, musical works, songs, compositions, dramatic works like a play, pantomime and choreographic works, pictorial, graphic, and sculptural works, motion pictures and other audiovisual works, sound recordings, and architectural works. So what cannot be protected? Like we said earlier, ideas, concepts, discoveries, titles, names, short phrases, and slogans. Those are actually reserved for trademarking, which we'll also go into in a bit. What about works that are not fixed in a tangible form of expression, such as an improvised speech or dance? Well, if it's improvised, then that means you're probably not going to have the same speech again and again. So how do you copyright something that changes all the time, right? Same with improvised dance. If improvised dance changes every time you're dancing, you can't really copyright that because it would just basically block everyone else who wants to do an improvised dance from doing an improvised dance. So things like that are not copyrightable or cannot be protected under copyright. But if you have an actual speech that's a written speech that you're giving over and over, it's the same every time, that is copyrighted. Works consisting of entirely information that is commonly available and contains no originality is also not able to be copyrighted. We talked about the light bulb or the apple, taking a picture of an apple on a table, and that is something that just about anyone could come up with. It's not really original, so it's not going to be able to be copyrighted. Anything written or created by the US government is actually uncopyrightable. And the reason is because the documentation or anything created by the government is public and it is for the public to consume. Things like building codes and stuff like that. Those are all documents that are that cannot be protected. We are able to publish them in books and whatnot. So if you own a copyright to something, what rights do you have? You're able to make copies of the work. So say you painted a beautiful watercolor painting of Schmeekley Reserve and you wanted to make it into some postcards, you definitely have the rights to make that into postcards. But if you make that painting and you display it somewhere and someone else decides to take a picture of it and they make postcards, then they are infringing on your copyright. You also have the ability to distribute copies of your work. So, if you hang that photo or that watercolor on the wall, you take a photo of it and you distribute the copies, that's fine. And people are free to, display them in their home. You're also free to display the work publicly, such as, for plays, or perform the work publicly, sorry, such as for plays, film, or music. Of course, if you wrote a play, you have the rights to performing it or designating who can perform it. You can display the work publicly, such as for artwork or any material you used on the internet or television. You can make derivative works of that artwork, including making modifications, adaptations, or other new uses of a work, like translating the work to another media. So say I made a giant bronze sculpture of the solar system, and I wanted to create that same sculpture but make it like a kid-sized model and sell it to children or children's museums, stuff like that. I can certainly take my giant bronze sculpture, translate it down into a plastic little adaptation of it and sell that as well. That's a derivative of my original work. Another derivative would be if I created another giant solar system bronze sculpture, but then added aliens to it. That second one with the aliens would be a derivative of the first. I could also modify it, say a year down the road it is falling apart and I want to put some new sculpture material on it, then I can do that. So basically you have free reign to do whatever you want with your stuff. And then you can also assign permission for anyone else to have these rights. So say you don't have the means to take a beautiful painting and distribute it, you might assign permission to somebody else to distribute it for you or create postcards out of it for you. So how long does copyright last? Copyright lasts for the life of the author plus 70 years following their death. So if you wrote a book, your book would be copyrighted while you're alive, and then once you die, it would be copyrighted for another 70 years. This is why there are a lot of old classic novels in public domain or free for you to download on like your Amazon Kindle and stuff. It's because these books have become property of the public, which is what public domain is. So we all own them, and we're free to read them, modify them, do what we want. And if a work was created by a corporation, copyright lasts 95 years from the date of publication or 120 years from creation, whichever expires first. The reason for this is actually because of Disney. Disney put, the reason that they extended it, and they'll probably continue to fight to extend it even more, is because at one point, Mickey Mouse was up to go into the public domain. And they didn't want their prize, money-making character to be just up for grabs for use by anyone. That would mean that anyone could modify Mickey Mouse, anyone could print Mickey Mouse on a t-shirt and sell it, and it was just too much for them. They wanted to maintain control of Mickey Mouse. So they petitioned the government and lobbied to have the copyright extended, and they won. And this is why copyright is longer for corporations. So when Mickey Mouse comes up to potentially being in the public domain again, you may see Disney fighting more for their characters to be left under copyright. What else is public domain? Works that have an expired copyright, so anything past that 70, 95, or 120 years. In the US, any published works before 1923, which is before copyright really even existed, those are public domain. Or any works that fell out of copyright for failure to register or renew under a 1909 Act, or for lack of notice before 1989. So do we have to use that little circle C copyright symbol? No, we don't. Since March of 1989, the copyright symbol is no longer required for published works. So if you paint a painting and you want it copyrighted, you don't need to put that copyright symbol on it anymore. It's a voluntary thing, but it's still recommended to use. I see it on the bottom of a lot of websites still where it'll say copyright, 2001, whatever the business name is. And that's the proper use of it. Proper use is, copyright 2011 Wilson Studios or copyright 2011 Disney. It doesn't have to have the comma in there, like between your name, but it can. So proper use is, copy, whoops, how's that one, the @ symbol? I'm gonna have to fix that in the slides, aren't I? Whoops. That's using, getting used to too many internet things rather than the copyright symbol. So proper use would be if this was a copyright symbol, the year, and the name. So let's discuss a few scenarios here. Who owns a copyright if, let's say you're a freelance artist and you create a beautiful painting for Century Insurance, because Century Insurance had a spot on the wall and they said, hey, you know what? We want you to build or to create us this beautiful painting to fill this space. Now, if they're not if they're not paying you as an actual employee and you create this piece of art, hang it there proudly, they may pay you for it. They may pay you a large sum. You could pretty much name your price on that one, whatever you negotiate for a price. But if you're still a freelance artist and you weren't working, as a employee of Century Insurance, that painting copyright still belongs to you. That's just like in the world of photography, when I photograph a wedding, regardless of who I'm taking the pictures of, even if it's, an important couple, somebody who's, maybe you see them on TV a lot, unless I actually sign away the rights to the images, they still remain mine. They remain my copyright. It doesn't matter what the subject of the art is. It's a matter of whoever created it. Whoever created it, that's who it belongs to. However, if you are working as an employee when you create this piece of art, so say Century Insurance hired you as an employee to create this painting, and you were actually put on their payroll, then the copyright becomes owned by Century Insurance because it was part of your job for them to create this piece of art, and it belongs technically to them, not you. It's just like you can't, if you're working for someone, you can't take everything that you make at work home. It's not yours, it belongs to your employer. So can a copyright be transferred? Yes, it can. In the cases of, like when I mentioned my photography, if I were to work for a really important couple and they wanted legal control over the images, I could either sign away the entire copyright, which would not be very smart. Really, no artist should sign away the entire copyright. Or one thing I can do is I can create a copyright license, and I can grant that license to, the wedding couple who got married and say, here, you guys, you have the rights to make reprints of these photos. You have the rights to display them on Facebook, but you do not have the full copyright rights and you cannot resell them, things like that. So I can designate how people can use my work. So if you're going to transfer an entire copyright, it has to be in writing. It cannot be verbal or anything like that. It has to be in writing and signed by either the copyright owner or somebody who's legally authorized to sign for them. So what is fair use? Fair use actually allows you to use copyrighted material for educational and research purposes without actually acquiring permission from the rights holders. So in many of my slides in this class, I've shown you YouTube videos, and those YouTube videos are copyrighted by the people who made them. And just because they're on YouTube doesn't mean that I can use them. But because I am a professor and teaching you this course, that makes it fall under fair use, and I am able to show you guys those videos without having to worry about copyright. Some other examples of fair use include commentary, search engines. So, if you're looking in Google and you find, in Google Images, it shows you a copyrighted image. Well, Google's a directory for you to find things like that. So they are pretty much exempt in that manner of copyright infringement. A criticism, you could be writing, you could be a movie critic and you could be writing a review of something. Parody is fair use, so you can parody something. You can report on it in the news without having to worry about copyright. You can research something and mention it in your research. You can teach, or you can be a library that archives and makes a library, I guess, of copyrighted works. And scholarship, again, for school. So while many other countries recognize similar exceptions to copyright, only the United States and Israel actually fully recognize the concept of fair use. Just an interesting little tidbit. So what are some factors that are considered in determining fair use? The purpose and the character of the use, including whether such use is of commercial nature or is for nonprofit educational purposes. So say I was showing those YouTube videos in this class. Let's say that instead of this class being offered through the university, let's say I was just recording it to put it online, or I was gonna sell a DVD of this class. So I was gonna put my entire course on the internet and say, hey everybody, come buy my Intro to Web Development course. It's really good. And then I was showing you guys all these showing all the YouTube videos, and making a profit off of this whole course. Well, then my use of fair use is pretty questionable because it would be commercial in nature, not for nonprofit educational purposes. Even though I make a salary with the university, my job is to teach you guys. It's really like a nonprofit educational purpose. I'm not actually showing you these videos to make a direct profit off of them. And that's why it's okay for fair use. The nature of the copyrighted work, what that means is if you have a song, it might be treated a little differently than a painting or something like that, or writing. The amount and substantiality of the portion used in relation to the copyrighted work as a whole. So even though in the beginning of the slides I said, if you're only using a certain percentage of something, it is still, you're still liable to be infringing on copyright. That's true. There is no set percentage of something that you can use to determine whether or not you're infringing on copyright. But if I were to, copy an entire painting and repaint it myself and try to sell it, like say I wanted to repaint Van Gogh's Starry Night and I was going to sell actual copies of it, well, I might be infringing on his copyright because I'm substantially copying the entire thing. But if I'm taking that and just taking a small portion of it, such as I repaint, I make a new painting and I paint the sun exactly how Van Gogh painted the sun in one of his paintings or something, or painted the moon or the stars the exact same, but the rest of the painting was different, then I probably, the substantiality and the amount of the portion I used in relation to the copyright work, would be taken into consideration as, oh, it's not really that, closely copied. So it's just something that is considered by the courts when they are looking at an actual copyright infringement case, or, to determine whether or not it's used in fair use. So the effective use upon the potential market or value for value of the copyrighted work. So say I took one of those YouTube videos and sent it all out to you guys for free when really you guys should have been paying for it. Well, then the owner of the copyright lost some money in that deal, and I might not be liable for fair use just because I've done that, really, and kind of made it so you guys can't, wouldn't be paying for the video. It's almost like pirating the video for you guys. And that would be, considered not fair use. They wouldn't look very favorably on me if I did that. And the fact that a work is unpublished shall not itself bear a finding of fair use if such finding is made upon consideration of all the above factors. What that means is, if your work is unpublished, and you still stole, content from somebody else, then you really aren't exercising fair use just by saying it's unpublished. You haven't published it yet. The fact that you created it in the first place is enough to be copyright violation rather than fair use, simply because you copied it. And they'll look at all the factors above, whether or not it's commercial in nature, how much of it you stole, how much damage you've done financially to the owner of the copyright material. And even if you haven't done that damage yet, it can be taken into consideration, if you had published it, how much damage would it have done? And you can still be liable for that. So let's say a reporter quotes a writing in a newscast, and they read a portion of a book, we'll say. Excuse me. And let's say they also criticize that writing. And a bunch of people in town see the newscast, and they're like, oh, we're not going to read that book now. Doesn't sound very good. Well, the author of the writing, who has registered the copyright, they registered it with the U.S. government. They see the newscast and they get mad, and they try to sue for copyright infringement, saying that he isn't selling any book copies due to the reporter's criticism. Let's say that reporter, maybe the reporter was Oprah. Oprah seems to have a pretty big effect on books, right? So was the reporter exercising fair use by criticizing the book, or will they be at fault? I'll give you a minute to think on that. So in this case, the reporter is actually exercising fair use. And that's because your opinion on something like a book or a movie or a screencast, anything like that, is actually your First Amendment rights rather than, infringing on copyright. So the author of the writing, even though they're pretty mad and they may not be selling book copies due to the criticism, there's nothing they can really do about it because the reporter did not steal their work for profit. If you go to the factors determined, the reporter was not using it for commercial nature. They weren't, they didn't read the entire book on air, maybe just a small portion of it. They did have an effect on the potential market or value of the copyrighted work, but that is more so because of their opinion on it rather than, something like they've actually sold it themselves to make their own profit. So really, that was completely fine with fair use, and the reporter will not get in trouble. So what is not fair use in the case of reporting? One of them is using a photograph or other image to illustrate a newsworthy story. Because the subject of the story is newsworthy, it doesn't make the image newsworthy. So say I am writing a story on the earthquakes in Japan and volcano eruptions in Japan, and I find this photographer's amazing photo of a volcano eruption in Japan. And I use that volcano eruption to illustrate my story about how Japan has a lot of geothermal activity. This would actually be copyright infringement. And that's because the subject of the story is not actually the image itself. I'm using that image to illustrate my article, my story. Now, on the contrary, if I was making this, if I used that image in a story and I was writing the article saying, look at this amazing image that so-and-so took of this volcano erupting in Japan, where there happens to be a lot of geothermal activity, this artist was in the right place at the right time and they caught this volcano erupting and it's a beautiful photo, blah, blah, blah. Well, that article would be fine because the subject of the article is the image. So it's only right that if you're writing about an image, you show the image. You could even say, hey, look at this really crappy photo. It doesn't even have to be, you don't have to be saying that it's good or anything, because that's again, the First Amendment portion, your first, your rights of free speech. So in that case, since the subject of the article is about the image, it's fine. But if you're using the image to illustrate a different article, then it is not fine to use without permission. So if you don't get permission, you would be using it illegally or under copyright infringement. And then similarly, what is not fair use is if you create a similar photograph that incorporates elements of the first photograph. We're going to see a couple examples coming up of people who wanted to use a certain image in an ad. They couldn't because negotiations fell through, and then they tried to recreate the image themselves. And in that case, they would be likely infringing on copyright. So how about this example? On the left was an image that showed up in a skit on The Tonight Show. And on the right is the original image created by a photographer. The Tonight Show did not ask permission to use this image, and it was not, as far as I know, it was not a stock photo. What do you think? Do you think the Tonight Show won this one? The Tonight Show actually tried claiming that that the use of the image was a parody. It was a parody of the original. But because the original is not even like a well-known photo, people wouldn't recognize that the image is an actual parody. So, the artist had the argument of, if it's a parody, it should be parodying something that people are going to recognize. If they see the image, they would recognize it as a parody of something. Same if I created a parody of, Vincent van Gogh's Starry Night image. We've all seen that image before. People, really recognize it. If I made a parody of that, well, it would be recognized that, just from looking at my image, not the original, that it is an actual parody. But in this case, the new image that was created by The Tonight Show is not, it doesn't really recognize, you don't know where that original image came from. And so the artist was suing them for copyright infringement. And this one was actually settled out of court because The Tonight Show, neither of them probably wanted to put up that big of a court battle. But Tonight Show also probably knew they were going to lose this one. And in that case, the artist likely would have won either way. I'm guessing they got a decent sum of money for The Tonight Show using their image. What about this case? SunTrust versus Houghton Mifflin Company. So what happened was an author created a new book called The Wind Done Gone, and used characters from Gone with the Wind and told the story from a slave's point of view. So they basically rewrote the book from a slave's point of view rather than the original Gone with the Wind view. The author of Gone with the Wind was pretty upset, and because the new book used the same characters, used some of the same storyline, but the courts called it a parody and called it fair use because it was pretty apparent that it was playing off of the original Gone with the Wind, which is still under copyright. So what do you guys think about this one? Let's say I copy pages out of a book and I hand them all out to you in class. So each class period, I copy a few pages and I hand it out to you guys in class. And over the course of the semester, I copy and distribute the entire book to you guys, so you don't have to buy it. The publisher of the book ends up finding out and is mad because, geez, they could have made $10,000 off you guys, right? Those books are expensive. And then they try suing me as the teacher for copyright infringement because I've copied the book for you guys and you've lost money, or they've lost money. And let's say I claim I was just exercising fair use, but will the publisher win in this case? So you can let's go back a few slides where we test fair use. Let's see, it's on slide 19. So factors considered in determining fair use, what's the purpose and character of the use? So my purpose is not to make money off of it. I'm not really using it commercial in nature. It is still for educational purposes. The nature of the work, it's a book. I'm copying a few pages of the time of the book. The amount and substantiality of the portion used in relation to copyright work as a whole. Well, if you look at it from a class time perspective, one class period, I copied a couple pages. That would certainly be fine as fair use. But over the course of the semester, I've copied the entire book for you guys. And then the effect of the use upon the potential market or value of the copyrighted work. So in that case, I've shrunk their potential market because you guys didn't have to buy the book. So I'm going to put that question on D2L as a discussion, and I'm going to have you guys at least make one comment in there whether or not you feel like I should be held liable and they should be able to sue me for $10,000 or more, or whether or not I was really exercising fair use. And let me know what you think and why. So we're going to answer this one in D2L. Let's go through some fun examples. Here's one. This is Food Chain Barbie. There you see Barbie in a blender, Barbie in a martini glass, some sort of dominatrix Barbie, and barbecued Barbies. So what happened was this artist created these photos and these situations and called it Food Chain Barbie. They were making a statement about the food industry and Barbie herself, I'm not sure. Mattel found out, of course Mattel is the maker of Barbie, and they were pretty upset over this use of their toy in this art. And so Mattel sued the artist, and in this case, the artist actually won. They considered it, free speech, fair use, that the artist was trying to illustrate a point, and they just happened to illustrate that point with the Barbie doll. And there really was nothing Mattel could do about it. I think they were actually lucky in that case. What about this one? Here's an interesting parody. That was it 1990 something, that Vanity Fair cover was pretty popular and pretty talked about because Demi Moore posed nude for a magazine cover while pregnant. And Annie Leibovitz, who is a famous celebrity photographer, took that photo. And eventually, the Naked Gun movie came out, and their movie poster featured Leslie Nielsen on the poster, posing pregnant, Photoshop pregnant, like Demi Moore. And Annie Leibovitz was pretty ticked off that her famous photo was ripped off in this way. But that photo was so famous that it was pretty obvious that the movie poster was a direct parody of the Vanity Fair cover featuring Demi Moore. So when Annie Leibovitz sued the movie studio that created this poster, the movie studio actually ended up winning on the counts that it was a parody of the original photo. What about this? This is an interesting one. This photo on the left, created by Art Rogers. A nice photo with a bunch of puppies. It ended up becoming a sculpture, a resin sculpture created by Jeff Koons, and the image or the sculpture, he sold it and created profit off of it. Now remember, changing the medium from, whether it's a painting to poster, postcard, or in this case, a photo to a sculpture, it's pretty obvious that this sculpture came directly from this photo. It was not coincidental in means, like you could take a picture of an apple on a table and somewhere in the other end of the continent, someone else could take a picture of an apple on a table. This is pretty coincidental that, or it's not coincidental, it's pretty easy to tell that this sculpture came from this photo. So the artist of the photo sued Jeff Koons, the maker of the sculpture, and the artist of the photo ended up winning. And that's because if you own, the copyright to that photo, you also own the means of distributing it or changing its medium and making derivatives of it. And in this case, Jeff Koons, the sculpture artist, had made a derivative of somebody else's work, and he was in the wrong. He infringed on their copyright. So he actually got in trouble for that one, and I think he ended up owing, money to the person who created the photo. Oh boy, there's an extra URL sitting in there. Whoops. So what about this one? This is another lawsuit that Koons has been in. In this case, he took some feet, which you can see it was in an advertisement on the left. The feet showed up in an advertisement in Allure magazine. I think it was for Gucci or something like that. Some famous designer with these, the feet and these fancy sandals. Well, Jeff Koons ended up taking these feet and using them in this collage that he created. I forget what he called it. He created this collage of, just women's feet and some food in the picture. And when the original photographer of these feet sued him, the courts actually decided that Jeff Koons would win this one because the feet were taken, they were colored, they were used to create a point. And the courts actually gave a really good explanation of it, which I've included in the link if you want to read it. In ruling that Koons' use of the legs from the copyrighted picture constituted fair use, they went through a detailed explanation of the 4-factor fair use test. So what's the purpose and character of the use? He was more so making a statement rather than trying to sell a bunch of copies of a painting or something. So, he wasn't trying to make a profit off of it, although he probably was. The nature of the copyrighted work. So it's a collage. It actually has pieces taken from different portions of different photos. They have the amount and substantiality of the portion used. So, you know, it was the entire, almost the entire portion of the original article, you know, the original advertisement. But what he had actually done is he actually colored in the legs themselves. So the advertisement was actually printed in black and white. Coons colored in the actual picture. So it was changed a bit. And then the effects on the actual or potential market for the work and its derivatives, there was really no effect on that original artist's work. They'd already used it in a advertisement. They had already sold the rights to it, you know, to use as an ad. They were probably not going to make any more money off of that image itself. And so there really was no monetary damage, and that is why they awarded Coons the winning end of this case. And he was able to still use the image of the feet, and it wasn't copyright infringement. So Jeff Coons, this is somebody that we're going to hear about a fair amount next class on Thursday. I'll actually talk about him a little bit more. He's an appropriation artist, another appropriation artist by the name of Stephen Ferry will also be going through. Yeah, he basically makes his living or makes his art by copying other people's pieces of art. So kind of interesting. So if you have a copyright to something, if you create something and you own its copyright, why should you worry? Why should you worry about registering the copyright? Well, you could get substantial, you know, monetary damages awarded to you. You could get, you know, it's actually $750 to $30,000 and up to $150,000 if the infringement was willful. So in the case of like Jeff Coons, he knowingly takes stuff from other artists. So in his case, he might have been fined up to $150,000 for stealing the image of the puppies and the two people on the park bench and making it into a sculpture. You know, the infringing use can be enjoined. You can actually have your attorney's fees covered if somebody infringes on your copyright. And it can be a criminal offense under some circumstances as well, criminal offense of theft. But who is responsible for any damages? So let's say a company, you know, the company that directly infringed, let's say I wrote an article and I put the article on my website and somebody else just basically picked it up and copied it word for word and put it on their website. And the company that originally stole it, they would be liable, as well as their employee who actually lifted it. They would be liable. The employee's supervisor, who should have been monitoring their employees' activities, they could be liable. And then anyone else who publishes the infringing image or text from there, whether they had knowledge of it being infringed upon or not, is also liable. So this is why news sources and PR companies really usually, they really need to take special care into finding the source of a story or an image or video or whatnot to make sure that it's okay for them to use. And that's very important because they don't want to be sued, right? I actually see this in the case of Huffington Post a lot. Huffington Post is notorious for stealing things from other people. A lot of times they do get permission, but a lot of times they don't as well. So if your copyright was infringed upon, how do you collect damages? Well, first of all, you should have it registered with the U.S. government. The U.S. government, I think it costs like $30 or whatever. We're going to go through it the next class period. You actually go ahead and register your work. And then you send them, you know, either a picture or a copy of the work. And they will archive it for you. And if anyone ever infringes upon that work, then you can say, hey, it's been registered with the US government, and if you can show that the alleged infringer had access to the original, you know, because sometimes things can come up and it could be completely coincidental. Like, you know, if I were taking a picture of an apple on a table again, you know, somebody else across the country could come up with the same idea, do the same thing, and then it wouldn't be infringing because it was actually, you know, two different people having the same idea. But if you can show that an alleged infringer had access to the original work of yours and that they actually copied protected elements of the original, you know, then you have a case where you can probably get some damages for copyright infringement. How about this one? This is a derivative work. So again, a collage. This person took elements from a bunch of different photos and put them into this newspaper cover photo. They took images from several sources. This one is actually case settled with attorney's fees paid. You know, it wasn't a parody. They actually stole pieces of another photo. You can see here, these are some of the originals. The city skyline, you can see that in the background. It's pretty apparent that those were pieces stolen from that art. And the two people running, which are identical to the original photo. So it's pretty easy to tell that this person who created this cover had access to the originals and copied them. What about this? This is substantial similarity. So this is actually a castle, I think a place that is pretty photographed by a lot of tourists. And in the case on the left, I can't remember which one sued the other. I think the one on the left was the original and the one on the right was the second one that was created, copyright infringed upon. They were in a big battle over whether or not the second one copied the first. And what the Copyright Office did when they looked at this case was, here's what they compare for elements. So they compare posing, they compare lighting, whether or not the person lit the photo. So in both of these cases, neither photographer actually lit the photo. The angle, the background. So of course it's the same background, it's the same castle, but actually this might be a space in New Orleans. It's actually the same, same subject of the photo. It's just taken from a little different angle. So the posing, posing and angle could be considered a little different. Background's considered the same. Perspective is a little different because you can see more of the fountain in front of the one on the right. Shading, well, of course, one is in black and white, the other's in color. And then the color, same thing. And viewpoint's a little different. So what they do is they examine the elements within the photographer's control. And in this case, they decided that it was simply a case of two different photographers, coming upon this beautiful scene and, popular tourist location, something to take photos of. And in this case, it wasn't copyright infringement because they weren't stealing one another's work. It just wasn't enough there to prove that one actually copied the other. It certainly could be coincidental or substantial similarity in that they both ended up at this place and took a nice photo of the image or of that subject. So remember we talked about earlier that an idea is not protected, only the expression of the idea is protected. So if I have an idea of, making a circle of light bulbs and taking a photo of it, it's not protected until I actually, make that circle of light bulbs and take a photo of it. where the way the idea is expressed tends to merge with the idea itself, there is no protection. And what I mean by that is this. So on the left, you have a famous photographer who photographs babies, and she was making these stock photos of these babies and selling them to a stock agency, and making some money off of them being sold as like a stock image. So people would buy that and put it in their corporate reports or whatnot. And that was her photo on the left. Well, then her stock agency was sold to Getty Images, and Getty is the biggest stock photo agency in the world. And she didn't want to sign Getty's ridiculous terms and conditions of being a stock photographer for them. So they couldn't use this image of hers. So what they then did was they hired other photographers to go ahead and create similar images of babies floating on a white background. And then they put those in their stock photos and used them instead of hers. And she, the original photographer, ended up, I think her name's Penny Gento. Penny ended up suing Getty Images for copyright infringement because they stole her original idea. But this idea and the way it's expressed is kind of merged with the idea itself. There is actually no protection on that. They said that anyone can take photos of white babies on a background and come up with that concept. And even though she was the first and she popularized it and made it, quite well known that it was hers, just about anyone could come up with that idea of, photographing floating babies on a white background. And they said that it wasn't protected. So Getty got away with it. And so this slide adds an article, link to an article about it in case you want to read more. And this last one, this is actually an advertisement. I think Microsoft ended up using it, but it was Microsoft that wanted to use the image. However, the ad agency that was actually doing the work was the one that got in trouble, because the image on the left is the original, I think, that Microsoft wanted to use, and negotiations broke down. The ad agency wasn't able to use it. They couldn't agree on a price for Microsoft to use it. And so what the ad agency did was they ended up hiring a second photographer to just recreate that image for Microsoft's ad. And because they lost out, because the ad agency stole the image, the original photographer sued them and sued Microsoft, I believe, as well, and for using a copyrighted image or copying your photo. The judge sent it to a jury, and the parties ended up settling for a confidential sum. And this is what happens in a lot of cases of copyright infringement. It's because the original photographer probably did not have enough money to really make a big case against big bad Microsoft. Because I'm guessing Microsoft probably, would have gotten in trouble too, because they actually used the copyrighted image, even though it was their marketing agency that was the first to take it. So the original photographer, if he didn't have enough money to really see the case through the end, Microsoft probably offered him a lower amount of money than what he would have gained and if he actually won a lawsuit, but who knows. So he was probably forced to just settle for a confidential amount of money and put up with it. So it's kind of sad in some cases where the artist, if you don't have enough money to really make a fight, then you don't really win out in that situation at all. So the next time next class, we're going to talk about tattoos. So what happens when you have a tattoo that's, can you copyright a tattoo? What happened a couple years ago was when the second Hangover movie was about to come out, Mike Tyson's tattoo artist saw that they were copying a tattoo that he, put on Mike Tyson, and he sued Warner Brothers because that was his copyright tattoo and they didn't have permission to use it. Well, is this considered derivative art? Is it a derivative of the original tattoo? Or is it a parody of the original tattoo? Warner Brothers was claiming that it was a parody. However, I believe they also ended up settling, but what do you think? Who would have won this one? Would Warner Brothers would have won because they parodied Mike Tyson's tattoo? Is Mike Tyson's tattoo known well enough to know, for people to know that it's a parody of it? Maybe. Or is it something that, because the artist created that work, even though it was created on somebody else, should the artist get paid money from Warner Brothers, or should the artist win the copyright infringement suit because they basically stole his design? What about Mike Tyson in this one? Does he get to have any ownership in it because it's on his body? So what do you think about that? Would you count it as derivative art or parody, or who would you award the money to in this case? Who would win the case? Would it be Warner Brothers or would it be the tattoo artist? And that's one we're going to discuss in D2L as well. And last, the third discussion in D2L that we're going to have this week is, what about all those people who got tattoos of Tweety Bird in the 80s? Or, excuse me, basically anyone who gets a popular cartoon character tattooed, right? Who's liable? Is it the tattoo artist? Because say you tattoo a Disney character on your arm, Disney might not be too happy about that. Who's liable for the copyright? Is it you, because maybe you designed the tattoo? Is it your tattoo artist, because they were the ones that drew the tattoo? Or is it the tattoo artist's employer, because they should be supervising what their employees are drawing on people? Or is it you yourself, because you are the one wearing the tattoo? So weigh in on that in D2L. I'll post a discussion, and you guys can tell me what you think about that as well. And that is all I have for today. Thanks, guys. Bye.